Welcome back to the Cordell Cordell and Men's Divorce Podcast. I'm Scott Trout, CEO and managing partner of Cordell Cordell. We continue to bring you the latest, some information, some talking points, educational tips for guys before, during, and after divorce with all things regarding family law, not just COVID related, but really divorce related modifications, paternities, contempts, you name it. And today is no different. But before we get started and introduce our guest, keep in mind that this is not to be taken as an attorney-client relationship. You know, if you're a continued fan of this, I always warn, just to make sure we're on the same page here. This is educational, informational. We want you to take these as talking points. And if you're looking for an attorney, find one that practices exclusively in family law. That's, I think, one of the most important things to do is someone that's familiar with it, as we are. And obviously, we have offices around the country, including the United Kingdom. And if you want an appointment, you can find us on the web at cordellcordell.com, or you can reach us at 866-DADS-LAW. We're happy to do a virtual using Zoom or FaceTime, telephonic, or we can do it in person where appropriate, keeping in mind your health and safety. So give us a call. We'll walk you through those steps, let you know what's available in your area, and obviously meet your preference and your needs. So let's get started. Mark, welcome. Thanks for joining us today.
Thanks, Scott. Thanks for having me.
So today we're going to talk about GAL. You often hear, now that term isn't universal. There's always variances around the country, child advocate, whatever it may be, a court-appointed advocate. But GAL, guardian ad litem, guys who have kids may hear this thrown about, not really truly knowing what they do. States, it depends on the different state, obviously, but I think generally when you're referring to these GALs, they have a common theme, a common meaning, and they have a common purpose in cases. So we'll start out, you are trained as a guardian, is that right?
That's correct.
So let's maybe just start here. Let's start by explaining to guys that are listening what it is, what it means for them, and then we'll kind of go through kind of how it works, what they're supposed to do, how they're appointed, kind of their capacity, their limitations, those types of things.
Great. Well, Scott, I think the most important thing to remember is that when we have children in these divorce cases, that by far is the most important asset of the case. And oftentimes we have two parties that are sort of competing against each other in terms of what they may believe is in the child's best interest. So we know that our judges and our magistrates, as much as maybe they would like to, they can't be the foot soldiers that actually go out and interview teachers and look at doctors' notes and the such. So what we do is we appoint really a third party who's totally disinterested from either party per se, and they are coming in solely to do a job that looks only after the best interest of the child. So each state is a little different. Here in the state of Ohio, we reference them as guardian ad litems. I've heard child advocates, so on and so forth. So it's a very important job. And in most states, it requires a lot of training in order to become a guardian ad litem. And most guardians, almost everyone that I know, really takes the job beyond serious. And because it is probably the most important component of the entire case is what the guardian is going to investigate and what the guardian is going to recommend. So it's very important to understand the importance of the guardian when you are entering your own custody case.
Yeah. And it could be, and I think when we talk about guardians in general, we've kind of glossed over the subject in podcasts before, and the 24 weeks we've been doing this, and for me, it can be a weapon that's for you and against you. I mean, you could deploy this weapon and it could be used against you, and it's very, it's one in which I would say to clients, don't flippantly just go in saying, oh, give me a guardian, and not understand what could or couldn't happen. I mean, first and foremost, the question I get is, and I'll have you answer is this going to cost me? Tell me what this is going to cost me, right? And so there is a charge, right?
That's correct. Every jurisdiction is a little different. In most cases, most of the jurisdictions here in Ohio, the fees for the guardian are split proportionally between the parties. Oftentimes it's 50-50, but let's say you have a situation where one of the parties makes 100,000 and the other one makes 30,000 a year. So then that might be a situation where the court will say there's going to be a 70-30 split. In other jurisdictions, and I think that gets to your point, Scott, it shouldn't just be something perhaps that we just flippantly tell our attorney that we want a guardian, because in some jurisdictions, especially here in Ohio, the initial deposit is incumbent to be paid upon the party that is initially requesting the guardian ad litem. And usually these deposit fees can be anywhere from $1,500 to $2,500 that have to be paid up front by the requesting party, obviously subject to further reallocation down the road. But in all cases, it's the responsibility of at least one of the parties, in most cases, both parties, to pay for this third party. In most cases, they are attorneys who are going to be brought in to really serve as the eyes and the ears of the court. And that's another a very important point is you want to make sure that you pay your guardian ad litem. That's one of the easiest ways to get behind early on is by not paying the fee.
You imagine, if someone who's going to make a recommendation, I want to talk about that in a second, you haven't paid them. I imagine they might be just a little bit influenced when you owe them some money. So it's a good point. That's why I want to talk about what is this going to cost me, because they got to be committed. If you're going to do it, be committed to paying them and making sure you stay on their side. So let me talk about that. Maybe I say it's an awesome power, and that's why I think some of them take it so seriously as they should, is that they are employed, and we'll talk about what to expect from them, to make a recommendation to the court regarding custody, right?
That's correct.
So these judges, and in my experience in Missouri and Illinois and Georgia, when these advocates, these guardians, they make a recommendation, absent something that just goes horrifically wrong in terms of the recommendation, which not based on fact or evidence or law, judge is going to follow pretty much what this guardian suggests as a recommendation, maybe with some tweaks. But that's why I say they have this incredible power in your case, and that's why it's very important to understand, number one, what they do. Do you need them? And when you get them, understand what you can do. So maybe you can comment a little bit about that power that they have.
I totally agree with you. And we have the same experience here in Ohio. I would say, 95 to 99% of cases that I've been involved with, whether or not I was the attorney or whether I was the guardian, that the court pretty much is going to rubber stamp what the guardian has come up with as far as a recommendation. So long as all of the, the proper rules are followed here in Ohio, we have a rule of superintendence that really details what our role is and our tasks are as the guardian. And so it is very important to understand the relevance of the guardian to the case and the power that they do have. And in most cases, I find that our judges and our magistrates, they care deeply about what the guardian is saying because they trust the guardian. And if there is going to be, perhaps a situation where a guardian is consistently maybe being questioned about their ability to do the job and so on and so forth, then our systems are set up to have the guardians actually maybe taken off the list for a while if they have too many cases and can't do that and so on and so forth. So I agree with you totally. It's a very, very important person in the case. And it's very important that each person going in that has a guardian is properly prepared and really knows how to interact with the guardian ad litem.
Yeah. I think, you think about this, judges don't like to make waves. And a lot of them don't. I mean, imagine having to make very critical decisions about who's going to have custody or who's going to have limited contact, drastically changing a family dynamic. And it's a tough job. So judges welcome a third party neutral where they don't necessarily hear, job of a lawyer is to tell a story. And so judges have an obligation to cut through all those stories to find out really the truth. And that's oftentimes difficult. And so I think in my experience, judges around the country love the idea of a guardian because they don't have to make that decision. And, absent something crazy where the guardian's, goes off the rails, that's kind of the danger of a guardian. It can work against you, it can work for you. And I think it's very risky at times. If you're a guy that's, let's say, Mark, you and I meet with someone and we say, look, your chances are outstanding. You've been the primary caretaker, you've been at home, mom's been at work. I don't see any reason you don't have any issues. To me, there'd be no reason to request a guardian at that point, unless you have a chance to lose what you think, get worse than what you have. And so it's kind of the reason I want to talk about this. I think it's a value is not only preparation, which we want to transition to next, but is having a conversation with your attorney about the need and the necessity for something. Because I always try to paint the picture. You walk in the courtroom, you have you and your attorney at a table, you have your spouse and an attorney at a table, and now what you're throwing in is this third party. And that third party typically doesn't sit in the middle. They're going to find themselves on one side or the other. And that visually, think about that. If you do something without, you don't prepare, you do something wrong, and you don't pay them, now they're across the table. They seem aligned with your spouse. And now you're not just fighting one attorney, you're fighting two to try to convince a judge that two people are wrong and you're right. And it's just a very difficult situation that of anything in family law, be careful what you ask for, because the result can be just devastating, right?
Yeah, I totally agree. Not every case that involves children needs a guardian ad litem. And I think that there is sometimes a rush in cases to get a guardian appointed right out the chute. And it's before, quite honestly, both sides have even really explored perhaps how far apart or how close they are. So I totally agree with you. I think oftentimes more than not, the decision for a guardian is made sometimes a little bit abruptly from the onset of the case, wherein if just perhaps a little bit of consideration and diligence goes into the thought process, you could be in a situation where you may not need a guardian ad litem, because exactly like you said, there's always a risk. And I come back to what a saying that I learned from you, Scott, actually, and that is that there's no winners in divorce. There's just multiple degrees of losing. And I think that's very true. I mean, in anything we do, I mean, the fact that we have to go into a situation where we may have to bring a third party in to make decisions that are going to directly impact our relationships with our children and so on and so forth, is just inherently sort of a losing situation for both parents. So it really does make sense for the attorneys involved in the case to get together, figure out how far apart both party stances are. Is there a middle ground before we have to really get involved with a guardian ad litem?
And I think it's interesting. I was talking to someone about medicine, and in the same in regards to recommendations in law, you're not required to do everything your doctor says. I always talk about, intentionally question your physician. Why? What will this do? What are the side effects? What if I didn't do this? And similarly with your lawyer. I mean, that's why I always liken medicine and law in some regards the same. We're trying to heal you of something, a bad marriage or cancer, right? I mean, yes, it's hard to compare those two, but the point is that just because a judge throws out in the middle of a settlement conference or a status conference, hey, let's get a guardian, you don't have to. And I mean, there are certain triggers. In Missouri, it's any allegation of abuse or neglect, it's automatic. So you got to be careful when you make allegations, because you're going to put yourself into a guardian situation. But absent that, you necessarily don't need to take it if it's in one of convenience, whereas you suggest judges may tend to just want a guardian. And I know particularly of a judge in this area that suggests a guardian in every single custody case because they don't want to make the decision. And call it lazy. I think it is. I mean, look, just take the evidence where it goes. So that's the point. I think it's just question everything, prepare, find out what's right for you, go through each case and or each instance of facts and what's going to help and what's going to hurt.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
What should guys do in preparation for meeting with a guardian? Maybe kind of go through a little bit of that. What's important in terms of getting ready for that first meeting?
Well, most guardians will send out a data sheet, and the data sheet really is sort of your blank canvas, because this is going to include all of your biographical information, but it's also going to include, for example, every important witness that you believe the guardian should have some interaction with, whether that's your parents, your brothers, your sisters, friends who observe you, and so on and so forth. So you want to make sure that it's a very deliberate thought in terms of just who you're putting down on that paper for the guardian to interview. You want to make sure that that person is going to say the right things about you. And oftentimes we have situations where, look, let's face it, two people are married, they have mutual friends, and, they all of a sudden announce they're going to be divorced. And we may not know who, either of those mutual friends are going to side with, so on and so forth. So it's a very important first step, is to make sure that you are filling out that GAL data sheet and reviewing that with your attorney. I think that's very important as well, just to make sure that you haven't forgotten anything. Second of all, I think it's very important to have and request that your attorney really prepare you for the first meeting. I know here in Ohio, I do a lot of mock GAL interviews with our clients here to get them really prepared. It's well worth an hour of time. And I think it really puts the client at ease, really, because they don't understand what the guardian's all about, perhaps. And it's a great opportunity to really feel what type of issues to really discuss with the guardian, and really just bring a sense of calmness and being prepared, knowing that the guardian's a very important person, that they're there to sort of be truth and fact finders themselves. So you don't want to over embellish a story, and you don't want to under exaggerate things also that may warrant the notification of the guardian as to really serious issues in the case.
Yeah. I mean, I think liken it to, I tell clients, hey, if there's an interview, you have a job that you really want, you mentally prepare, you go through kind of what could they ask you? What do you want to tell them about yourself? Not that you're putting on a show or a facade, but you're preparing for something as perhaps unimportant comparably. I mean, it's unimportant compared to your kids, right? The kids are everything. Everything that's the most important thing on the planet right now is your kids. So prepare. And that includes, as you suggest, a mock interview. Knowing what you want to talk to the guardian about, eliciting all of your positions, making sure they know the important facts, not forgetting something that is what may be looked at as, well, if it wasn't that important that you couldn't remember, then why am I hearing it now? This is the most important interview you will have, because first impressions are everything. Judges do the same thing. They're going to look you up and down and make a conclusion about you, good or bad, right or wrong, within the first 5 minutes. It's a bias. And they're going to do it. And so these guardians will do the same thing. You have an opportunity, whether it be a 60-minute interview or meeting with that guardian, to impress and to convince them that what you're saying is correct and the way it should be. So don't, as you suggest, set a meeting with your attorney, sit down, go through practice. Let's talk about what there is. What are they going to ask you? I mean, I always, and I mean, you can comment and then we'll wrap up, is I know most of these guardians, and I know their history. I know kind of what they like to do. I know where they lean. I know the direction that they're going to go. I know what they may ask you. I know what really upsets them, kind of based on history of the cases that I've had. So, I'll let you have this last word here on that issue.
No, I totally agree. And every guardian's a little different, but just it's something as being as prepared to know, for example, what's your child's favorite color? What's your child's favorite movie, or something like that they're into. You'd be surprised the amount of people that perhaps don't know these very basic type of important details that you should really know about. So each guardian is different, and I think anyone who is practicing family law should know, as you said, they should know the guardians that they're utilizing. They should know their strengths in terms of their client, in dealing with what a guardian in any particular situation may ask or not ask. And so that comes down to the preparation. So, just be prepared and make sure that you are detailing things with your attorney so that you are prepared, because I think that is the key to the case. The guardian has an important role, and probably the most important role of any of the participants in the whole litigation.
It is. And I mean, it's knowledge, understanding. I mean, I think one of the reasons we do these podcasts and have been doing it for the entire duration of COVID is to let guys understand the process, the players. It's like, having someone watch a football game or a baseball game for the very first time, not knowing the rules, how they score. It would be less interesting if you had no idea what it meant when they crossed the goal line. You're like, well, what does that mean? I mean, when it's 4th and 1 on the 1, what's at risk, or what's to gain here. That's the point. Know the rules, know the players, know the potential and the possibilities, the likelihoods. And so great, Mark, really good stuff today to really explain to guys out there what this GAL mystery is, because we just don't talk enough about it. So thanks for joining and enlightening guys listening.
Thanks, Scott. It was my pleasure.
Well, we'll continue to bring you hot topics with diving as deep as we can in the 20 minutes that we have with you each week and things like this. So again, you want to reach out and have more questions for Mark, you can reach us at 866-DADS-LAW, set up a consultation, or with one of our other Cordell & Cordell attorneys around the country, including in the UK. You can also find us on the web at Cordell Cordell. Social media, you can find us there, and also our YouTube channel, where we have podcasts there, as well as our virtual town hall. We have one coming up in September where you can log in, ask questions live of our Cordell and Cordell panel of attorneys. You'll get answers right then, right there. So go ahead and find us on the web, register for that virtual town hall coming up in September, and continue to tune into our podcasts that we hold twice each week. Until next time, have a great week.